Good afternoon, everybody. Thank you all for being here today for a live webinar. The title is Employers Beware, New President, New Cabinet, New Executive Orders, New HR Headaches. For those who don't know me, my name is Peter Siegel. I'm a labor and employment law partner at the law firm of Greenspoon, Marder. I've been practicing labor law since 1993, and I also serve as the law firm's chief employment officer. With me, and he was with us again last December when we did our last webinar, Leiva. Alex, are you there?
I'm here, Peter.
All right, Alex, good to see you. Thanks for joining us again. And listen, everyone, we're very excited about today's presentation. We chose 6 topics. I'm confident that all of you will find them very timely and hopefully related to your everyday work in HR, on C-suite. Anywhere where you run your business, I think you're going to find these topics to be hopefully relevant to your day-to-day work. Now, just a couple of housekeeping bits, and then we'll get this thing going. First of all, we have a terrific turnout today, which makes us happy. And the reason it's really exciting for us is we have a wide array of industry represented here today. We have folks in education, we have schools, private, public, charter, we have healthcare, we have hospitality, hotels, restaurants, bars, clubs, we have manufacturing, we have first responders, we have some law enforcement. We have folks from almost every different field. And I think that's important, and Alex and I discussed that this morning, because my hope is that everyone is here, and including all those who joined us in December, not because I'm here or because Alex is here, or maybe not even because of the topic. Our hope is that all of you are here today because you believe in the cause that Alex and I have been working on for years and years now. Alex, you joined us back in 2014 when we hired you out of law school. And I told you I remember when we even interviewed you, we talked about this crusade of ours, at least in our employment law consulting group, about stopping employee lawsuits, or at a minimum, just reducing employee lawsuits. Because as we've all discussed, and I've discussed this with many of you on a one-on-one basis, once an employee files a lawsuit, in our view, there's only going to be one guaranteed winner, and that's the lawyer or the lawyers who are working on the case. The lawyers are going to get paid, but for the employee and for the employer, very little good comes from that. And what I mean by that is some will say, well, what if the employee wins the case or the employee gets a good settlement? Good luck to that employee in the future when they go try to get a job at another company and their litigation history is public record. Many companies today, while they won't admit it, are going to be very concerned and reluctant to hire a candidate who has a history of suing their former employers. And for companies, we have this debate all the time with CEOs and CFOs and ownership and boards of directors. Well, they'll say, well, Peter, if we get sued, you know what? We have insurance. That's okay. Or we have the money to fight forever. But does insurance and the deep pocket help you with disruption, with employee morale decline, with employee turnover, with dissension, with bad optics, with media coverage? Alex and I had a meeting a couple of months ago with a client, preparing the client and the client representatives for depositions. And during that meeting, all I could think about was what a terrible, ineffective, and wasteful use of their resources. These folks should have been in their office, working, making money. For-profit folks we have on the phone, social service agencies who are well attended here right now as part of this presentation. You shouldn't be spending time with us preparing for depositions and mediation. You should be serving the clients in need in our communities who depend upon your services. So whether you're for-profit or non-for-profit, the goal needs to be the same. Let's take these simple steps. Let's help you with a navigation, with a plan to minimize the risk of employee lawsuits. Take a fraction of a litigation budget, spend it toward prevention, spend it toward preemption, spend it toward policies, handbooks, contracts, non-competes, arbitration agreements, training your managers. That's a good use of money, and it's a heck of a lot less money than is litigation. So again, lawsuits do happen. There is no 100% immunity, okay? But what we've been able to do that I'm most proud of in our employment law group is to minimize the risk of litigation. And we've seen a tremendous decline in lawsuits among those who work with us on a regular basis. So that's what we're going to talk about. Thank you again for being here. One bit of warning, we go fast. You know that. We have a lot of topics in 60 minutes. We've narrowed it down to these 6 subjects. So without further ado, Alex, we're going to get going. Our first topic, again, vaccinations, vaccinations, vaccinations. That is what everyone is calling about. That's what everyone is emailing about. And let me just give you today's statistics, Alex. From as of 9 o'clock this morning, we have about 45 million Americans have received at least 1 dose of the vaccine. So 45 million Americans have been vaccinated. That's about 13% of our population. What does that tell us? It tells me that for folks who are already working on premises where you're getting people back, about almost 80% or 85% of your staff, of your employee workforce is unvaccinated. And you've got to make the decision, as we've all discussed. Are you going to have a mandatory vaccination policy, or are you going to have a voluntary vaccination policy? Voluntary meaning you encourage, you facilitate, you subsidize, but you don't mandate it. Alex, we all met back in December, on December 18th, with a lot of the folks who are on with us today. What has happened since then? Where is the EEOC on this issue? And do our clients still have that choice, whether they want to go voluntary or mandatory?
Peter, to answer the third question first, yes, they still have that choice. And in fact, in a bit of good news for employers, what was it, about an hour or less after we concluded our most recent webinar, EEOC finally gave us the guidance that we were waiting for. And what they said was a vaccination requirement is not a medical examination for purposes of the ADA. Now, that doesn't say much by itself, but in the context of what you and I do, Peter, that means that employers can require it in their workplace, subject to a few rules or exceptions that you and I have found too common and commonplace for the last 10 years since we've been talking about vaccinations since H1N1 in 2009, 2010. And those rules, Peters, are the things that our clients and everybody joining us today need to remember. And I could go through them quickly, but they're pretty simple. The first thing is, yes, you can have a mandatory vaccination policy. And yes, you could require it for employers to either come to work or to actually work in your workplace, okay? Whether that be presence or in person with other employees or in client-facing positions, okay? The first thing they need to remember is if you're going to do it, be careful with pre-screening questions. And what I mean by that, Peter, is it's okay to implement a mandatory vaccination policy, but don't start asking questions or be weary of questions that could elicit disability-related information, because you would go from being able to do a mandatory vaccination policy to now pretty close or actually violating the ADA, okay? So that's the first thing. The second thing is remember ADA accommodations and religious accommodations, okay? And what I mean by that, and Peter, you and I have just dealt with this question about twice in the last 2 days or 3 days. The first thing is if an employee asks you for an accommodation based on a disability, it is illegal to immediately proceed with termination for not complying with a mandatory vaccination policy. What employers must do on the contrary is simple. Engage in the interactive process that we've been talking about for 3-4 decades, okay? It is consider accommodations, okay? It is see if remote work is available, if a different position is available, if a non-customer or client-facing position is available. Employers must go through that process. They must do it before they can determine whether or not they can exclude someone from the workplace or can actually terminate them altogether. The same is true with religious accommodations. If an employee approaches an employer and says, I cannot get vaccinated because of X religion, it is important to engage in the same interactive process. And one thing, Peter, you and I have discussed, and we find it interesting because we're weird like that, is what was not a reasonable accommodation 6 years ago is now a reasonable accommodation. And what I'm referring to, Peter, is the remote work arrangement. 6 years ago, how many cases, 7 years ago, how many cases have we defended where the first thing we would argue is remote work wasn't a reasonable accommodation, and therefore our client was able to terminate for that reason? How many cases? It's endless. Nowadays, because we spent the last year in a remote work environment for many of many industries, okay, throughout South Florida and throughout the country, courts are going to be inevitably more reluctant to declare a remote work arrangement or a continuation of that arrangement as not a reasonable accommodation. So those are the three tidbits we need to remember with respect to mandatory vaccination policies.
No, and I think those are all excellent points. And just to bring this home to real life situations that we've been consulting with clients this week and last week on, you are going to have, as Alex said, if you go mandatory, again, you can do it. We have long-term care providers here as part of this webinar. We have people who have nursing homes that they run. For those folks, you already have mandatory policies because you don't have a choice and you cannot put your clients in harm's way, okay? But for those who are on the fence, for those who aren't sure if they want to go mandatory or voluntary, I think what we need to tell them and tell all of you is the following. Some folks are going to object to mandatory on religion, and we're going to do what Alex said. We're going to consider the request. We're going to make sure the beliefs are reasonably held, and we will maybe come up with an accommodation that allows them not to get fired, but perhaps they continue remote work or something like that. We think of a way where where their religion actually doesn't have to be compromised. The disability, the health issue, we've already spoken about. There are some employees who are going to tell you that under the CDC most updated guidelines from this week, it talks about a very small part of the population, very small, whether it be Pfizer, whether it be Moderna, whether it be the J&J that just got a EUA approval last night, which is very exciting. But whether it's one of those cases are few and far between where someone will have an issue. And the issue usually will be a severe allergic reaction. So consider the religious exemption, consider the disability, but the third objector you're going to hear from, and we dealt with this twice already, as you said, and we dealt with this last week. The third objector is a person who says, hey, Alex, I don't want to take a vaccine. I don't believe in vaccinations. I don't think they're safe. In fact, I believe that they're part of Bill Gates' plot to put microchips in my bloodstream, and the government's going to monitor me, and no vaccine for me. Alex, do you agree that under the current state of the law, that is a person who can be terminated without pause?
100%. And that is by far the easiest decision we're going to need to make with respect to these three groups. And what I mean by three groups, the anti-vaxxers, the religious accommodations, and the disability accommodations. The anti-vaxxers, Peter, you and I have concluded in the past, and our opinion remains unchanged at this point, that there is very little that stops an employer at this point from terminating that employee, just because there's no protected characteristic involved here.
Yeah, and last thing I'll say on this point, someone called me yesterday, and he basically asked me, the CEO of a company, and he said to me, what is the worst case scenario if I go voluntary, and what is the worst case scenario if I go mandatory? If you go voluntary, which many of you are, the only bad scenario is that it's going to take a heck of a lot longer for you to return to normalcy. The number one fear of employees coming back to work today, coming back to a physical office, is their fear of getting COVID. We know that. We also know that in the 10 biggest cities right now in the United States, the most recent study just said that 23% of workers are back at their desks. Just 23, so that's less than 1 out of 4. So if you're okay with the remote work at your business now, if you're finding that your revenue and your margins are looking good, if you're finding that your clients are satisfied with the remote setup, you really don't have an urgency to go mandatory. If you can wait it out, then continue, and as the vaccines become more available, no need to compel. But if you're one of those employers, like an increasing number, who need to be back at work, who want to return to the way things were the best they can, who have clients who can no longer live with this remote setup, you need to seriously consider a mandatory policy. And the risk is, and Alex already addressed it perfectly, the risk is you'll get caught up on one of those exemptions. You'll mishandle a request for religious accommodation or a disability accommodation. So be careful, understand the exceptions, and be sure to work with your attorneys, whether it's us or whoever your attorney is, to make sure that the objectors are handled properly. Alex, anything else on vaccinations before we move on?
Yes, I got actually an interesting question that just popped in.
Sure.
And the question is, Peter, with respect to COVID-19 testing, not vaccination, is it possible that those accommodation requests are permissible or even frequent from our experience? And I can take that one, Peter. The answer is yes, our clients have seen it, but between all of us here on this webinar, it's a worse argument than it is for the accommodation request for vaccines. So technically, do you have to consider the accommodation request? Yes, but the reasonable accommodations and what employers have to do, it's going to remain the same. Can the employee still work without putting your customers and your clients at risk? If the answer is no, is there a remote work arrangement? If the answer is no, is there a way where the employee can be staggered from coming in to into times where there's no clients or there's less employees? If the answer is no, then consider unpaid leave. If the answer is no, then we all talk and see if we could terminate. But that's really the same process with respect to COVID-19 or vaccination.
Perfect, perfect. And again, what I'll just say in conclusion on this issue, the rollout is continuing. The rollouts are going to be increasing over the next few months. Many of my clients are already targeting mid to late summer or maybe Labor Day, September, to fully bring people back. But it is you, the employer, who will make that decision, mandatory or voluntary. And once you make that decision, work with us. We'll make sure your policy is legal. We'll make sure you explain it properly to employees. And we'll make sure that whatever side you choose, both of which are perfectly legal, that it's handled crisply and properly and without incident. All right, topic number 2. Alex, this one, again, has really been exacerbated. This is the issue of free speech in the workplace that we love to talk about. After the events of January 6th at the U.S. Capitol, I got a call from a head of a company based in New York. The company basically calls me up and they say, listen, they're watching everything on television. They're watching a country where the political divisions are incredible. 81 million people voted for Biden, 74 million for Trump. We're pretty much a 50-50 nation. We know, and this is the discussion I had with this person, we know that the divisiveness of our country is also reflected in each of our workplaces. It's just basic law of averages. So the question this gentleman had for me was, what can he do at work with all of his employees and all his managers to bring down the temperature? Okay, he understands that if people are debating politics in the hallway and they're screaming at each other, just like with religion, just like with anything else, the employer can go there, tell them, hey, everyone cool it, talk about this after hours. We respect political views, but you are here to work. We are paying you to work, not to debate politics, not to yell and scream at each other. So that one's relatively easy. But his concern was what we're seeing now, even with masks. And Alex, a year ago, did we ever envision a scenario where people were now taking political views, political expression, and wearing it on a mask at work, so they're complying with the COVID CDC guidelines, but now they're injecting politics at work? You and I have had calls about MAGA masks, Donald Trump masks, Joe Biden masks, Bernie Sanders masks. We've had 2 Black Lives Matter mask issues to deal with. We had a situation where someone had a Confederate flag mask at work and people were flipping out, and we're getting the calls. So Alex, talk to everyone if you would. Where are we on the law right now with this? We know we had the Whole Foods decision in Massachusetts earlier this month. Where are we on this? because we had a call, was it on Tuesday, where a CEO said to me, hey, Peter, I can't monitor politics because of First Amendment. And I know it's pathetic, but I do carry one of these with me, a Constitution, and it's sad, I know, but I do. And I had to read from the First Amendment to this client. And I read the sentence that says, Congress, the government shall make no law abridging the freedom of speech or of the press or the right of the people to assemble peaceably. The government cannot take away that First Amendment right, but an employer, a private employer, put aside public employees, that's a separate topic for another day. But for private employers out there, you guys understand your employees do not have a First Amendment right to free speech at work. We have had cases where an employee walks into the boss's office and says, hey, I think you're a big fat idiot. And the employee gets fired and it becomes a whole thing. Well, doesn't he have the First Amendment right? No, he doesn't. You can't have a newspaper at work where the headline is, I hate this place. Everyone I work with are jerks and I want to leave. Everyone here is terrible. There is no freedom of speech in a private place of employment, Alex. We know that. Everyone else needs to understand that. And with masks, we've seen it. Tell me the advice. Tell me the best policy for companies if, again, the goal is respect political differences, but keep the temperature a bit lower.
And Peter, thank you for highlighting one of the biggest misconceptions that we've been dealing with for the last several months now in the midst of the election and the various televised debates and so on. So the way to get around this, and by get around this, I mean the way to lower the temperature and ensure that you don't end up like Whole Foods, even though they kind of won. But the fact is they had to defend a class action complaint for race discrimination. So in order to avoid that,
Tell me, excuse me, what happened though with Whole Foods? Tell me why they got sued. What happened?
And Peter, just briefly, Whole Foods, like other companies, national companies throughout the country, Taco Bell, Costco, Starbucks, got some bad media attention and even started facing lawsuits because they began the implementing the policy of banning Black Lives Matter masks at work, specifically Black Lives Matter masks at work. And what happened was employees filed class action complaints saying that was essentially tantamount to race discrimination under Title VII of the Civil Rights Act of 1964. Now, what happened in that case was a win for employers. And what the court ultimately found, in fewer words than what the opinion provided, was essentially, if you have a dress code that is neutral, that is applicable to all masks and all type of expression, regardless of whether you supported former President Trump, whether you support President Biden, whether you support Black Lives Matter or not. If it is applied, regardless of your expression, regardless of what group you fall under, then that policy standing alone would be enough to violate and to control and to manage these types of expressions in the workplace. And what I mean by that, Peter, and I just helped a couple clients throughout the last few weeks on this very issue. What we've done and the way that our clients should be handling this is tied the control or the dress code policy to the mask. And what I mean by that is if your dress code policy is, for example, a plain black shirt and khakis or a plain black shirt and jeans, you can then tie the mask wearing requirement to say you could only wear masks without slogans, without sayings, without obscenities, without any logos. You can wear masks that are either plain in black color, ones that have the company logo, ones that are medically provided, K95. You can wear one that has no symbols, a plain color, a neutral color, just like you would ordinarily control a dress code in the workplace. And that is the reason why Whole Foods won. And that is why they may likely win once this case goes to appeal. So Peter, the short answer of it is lower the temperature by applying consistent policies, regardless of the view, regardless of what group you fall in.
So basically what we're saying is we're going to try to keep politics out, and the mask wearing is not going to be a vehicle through which you express political views. So the argument is, I guess, no one can do it, right? In a certain policy. And if no one can do it, then no one can complain because we don't care if it's liberal, conservative, left-wing, right-wing, Democrat, Republican, or other. We're going to say in a potential dress code policy that your mask should not be an opportunity for you to argue politics.
Absolutely. 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 And again, and I have a couple questions that are popping in now. The analysis and the discussion is different if you are a public employer. And in that case, you are significantly more restricted in what you can control and the type of speech that you can limit in your workplace.
Right.
And in that context, that's a conversation we need to have in greater detail that unfortunately the hour or less than an hour we have here is not sufficient time to do that. But again, for those private employers that are not part of the government, you are not a public employer, you have significant more leeway in how you can control or lower the temperature when it comes to politics in the workplace. But Peter, and I know you and I have dealt with this issue many times, even prior to this election cycle, there are some states and localities that do restrict discrimination on the basis of political affiliation or outside political activities or recreational activities, what you do while not in the workplace. So that's also
right. But that's a whole separate issue when we're outside the workplace. I think, and I'm glad you raised that because we just had a question a second ago, and someone just asked, can you be fired or can you terminate an employee technically if for them simply being seen on television attending a political rally? And again, under federal law, believe it or not, there really is no federal protection in that regard, meaning an employer could, and we do not recommend this, they technically under federal law could terminate someone, an employee, because they saw them on the local news attending a rally for a candidate whom the owner maybe didn't like. We never recommend that because even though federal law doesn't speak to that, many state laws do, as Alex just said. That would be a lawful activity outside the workplace. 30 states currently have those protections. So you're never going to want to terminate someone simply because they went to a rally for a candidate you don't like, because that's not at work, it's outside. However, and circling back to where we started this topic, January 6th at the U.S. Capitol, what was interesting was not only the hundreds and hundreds and hundreds of people who have been arrested, but most of those folks have been terminated from their jobs in a multitude of states. And the lawsuits haven't been filed yet. And the reason is no lawyer will take that case. And the reason a lawyer won't take those cases is because with the Capitol issue on January 6th, you had theft, vandalism, trespassing, you had a lot of crimes taking place. Thus, it's no longer lawful activity outside the workplace. And in all 50 states, an employee can be terminated for engaging in unlawful activity outside the workplace, even if there is no direct immediate impact on the day-to-day in the office. So listen, here's the upshot. There is no, for you private employers, which is 97% of you right now who are participating, there is no free speech in the workplace. Keep the temperature down, encourage people with politics, do what they wish, but don't bring it into the workplace if you can help it. People work for you, you pay them for the most part to work, to generate revenue, to provide social services, to serve customers, and to serve clients. That's why they are there, and that is where their focus should be, not on anything else. Anything else, Alex, on topic 2, if we go to number 3?
Just quickly, just to circle back on that example you gave on those states that protect lawful activities outside of the workplace, even in states like New York and Connecticut, where the law is in the books, there are exceptions for engaging in illegal activity. So simply because there's a statute on the books that protects lawful activities to start with, it's not a way where employees can wave it in your face and start saying, you can't terminate me, I'm protected. There's always a caveat for, like you said, Peter, things that are illegal or things that inappropriately disrupt your operations in the workplace. If it affects those two things, more likely than not, employers are going to have leeway, even when those statutes exist.
Absolutely. And again, a state-by-state analysis. We're fortunate, as I said, to have not only people from so many industries today, but we have people from throughout the United States. You need to look at your state law. If you're unsure, let us know and we can send you a quick opinion letter. I did have a question from someone. What about the person in 2017 who was terminated for giving Trump the finger? That's a true story. Back in 2017, a woman by the name of Julie Briskman was riding her bicycle. The Trump motorcade came by. She gave the motorcade the finger, was terminated by her employer and sued. Long story short, she actually won the case in terms of severance that was owed to her, but she lost the wrongful termination case. The court concluded that under Virginia law, an employer can't terminate an at-will employee because the employer did not like what that person was doing off duty, off premises. In that case, it was giving the former president the finger. The ironic thing about the Briskman story, if you ever want to Google it, is a year and a half after she had a split decision on her lawsuit, she ran for office in Virginia for a county political position. Her whole campaign was based on the fact that she gave the former president the finger and she won the election. And now Julie Briskman is an office holder in Virginia. So that's just a little trivia. Do with it what you may. Next topic, Alex. This is huge. In December, we spoke about the FFCRA. Many of you remember, hopefully, the first time ever, back in March of 2020, we had this law, federal mandate with respect to paid leave. FFCRA, Families First Coronavirus Response Act, and just to refresh recollections, basically what that law said was, because of COVID, because of the way the economy was decimated so quickly, the federal government decided that for a certain period of time, companies are going to have to offer paid sick leave, even super small companies who normally wouldn't be subject to state or federal law on these issues. So there was a requirement for 80 hours for paid sick leave, 12 weeks for emergency FMLA leave, all COVID related. But the thing that we talked about in December, Alex, was, hey, this law, this FFCRA is going to expire unless someone does something about it on December 31st. And we were kind of predicting what's going to happen. Is it going to be extended? Is the law really going to go bye-bye? So Alex, here we are. It's February 25th. What happened with the FFCRA? Did it indeed disappear on December 31st? And what does that mean for employers today when an employee says, I need paid leave because I'm having a coronavirus issue that precludes me from working?
So Peter, required compliance with the Families First Act went bye-bye. What didn't go bye-bye and what was extended was the option for voluntary compliance. And what I mean by that is through March 31st, Congress has said for those employers who want to voluntarily provide FFCRA leave to those individuals who had not already used the sick leave, okay, you are allowed or potentially eligible for tax credits, okay? But those tax credits expire on March 31st. Absent some other extension, which is still possible, let's not forget that it still may be on the table. That is the extent of the Families First Act. So now it's voluntary compliance from January 1st through March 31st, and that voluntary compliance, the most it can get you are those tax credits.
So what are you advising clients? We had a situation last week. A company calls us up. An employee had legitimate coronavirus-related issues that she had to take care of. She requested some paid FFCRA leave. Why don't you talk about how did we advise that and what did we recommend that the client do in that situation?
So Peter, a lot of our clients here that are on this webinar that have been dealing with us over years, they know that we typically approach a situation in two ways. One, is it legal or is it illegal? And two, what is the perception? And the reason why we do that is because setting aside the legality of whatever decision we're taking in the workplace, perception alone can be enough to trigger an employee to find an attorney, to send a demand letter, to file a lawsuit, and already cause the company to incur legal fees, expenses, headaches that it could have resolved or avoided had it done the thing that just felt right, that it passed the smell test. So legally, the legal question is there. It's voluntary. You're not required to do anything in terms of the Families First Act. In terms of perception, Peter, what we've been recommending at this point is if you could afford it, if the finances are there for your business, continue to comply with it. Because what happens is no one is going to fault you for doing more than you are supposed to do or than you're required to do under the law. In fact, how many times, Peter, have we used that as a defense in our cases, right? Your Honor, how can we discriminate against an employee if we did more than what we were required to? Clearly, there was no discriminatory intent there if we were giving more than we were required to. So again, if you're able to afford it, if the finances are there, if the employee had not otherwise exhausted leave, or even if they did exhaust leave, and you could give them some sort of paid leave where, ordinarily paid time off wouldn't be available under company policy, do it. One, it's not only the right thing to do, but it also, more importantly, could help you avoid a lawsuit down the road.
And also, I would tell everyone on the webinar right now, and we have some very good accounting firms who have joined us. Good to see all of you. Talk to your accountant about these payroll tax credits. They are dollar for dollar. And what I mean by that is, if you have to shell out some paid leave to help someone with 80 hours, that's it, of some paid coronavirus sick leave, if you do that between now and March 31st, you're going to get that money back, most of it, if not all of it, and good accountants have had some good results with that. So that will address the issue of affordability that Alex has properly raised, something to think about. So Alex, the FFCRA, it's kind of the past now. We have the voluntary issue through the end of March, and then it's officially bye-bye, as we say. Let's talk about the future with paid leave. We, in December, this webinar, we talked about the Family Act. And since we spoke about that, Senator Gillibrand, we have some New Yorkers with us today. You know Senator Gillibrand, one of your two New York senators. Senator Gillibrand has already introduced this bill, Alex, in the United States Senate. She says they have the votes, as we said in December, paid family leave. Unlike the FMLA, which is 12 weeks of unpaid leave, but paid family leave up to 12 weeks is politically popular. It is incredibly bipartisan. Senator Gillibrand says they have the votes. President Biden said he will sign that bill if it gets to his desk. There's some talk that could happen in the next few months. Can you talk a little bit about what the Families Act is, what our clients and other companies need to know, and what it means for their employees versus the current FMLA?
So, Peter, for those employers, so for those individuals joining us today from states like New York and California, you're going to see that the Family Act, the one that's been proposed, is nothing new to what you were already experiencing in your respective states. And what I mean by that is, and again, everybody else can kind of ease into this a little bit more now that what I'm about to tell you. Pay leave is not going to come directly or solely from an employer's pocket. Okay, the Family Act is essentially what states like California and New York are doing through payroll contributions from both the employee and the employer. There's going to be a program that gets funded. And what that provides is up to 66 or 2/3% of wage replacements for that 12-week period. So again, is it pay leave that isn't otherwise provided under federal law? Yes. But is it as financially burdensome as you and I would have thought would have been the initial proposal? No. And and this is an important caveat, Peter, unlike the Family and Medical Leave Act, there's likely, under the current version of what's been proposed, there's not going to be an employee threshold. So this 12 weeks of payroll contributions provided leave is going to apply to employers regardless of size. And that's a key distinction. But again, a lot of people joining us today can rest easy, knowing that it's not going, if this is the current version that gets accepted and signed by President Biden, it's not going to come 100% from the employer's pocket.
And I just got a question in, and the question is, under the Families Act, as it currently is proposed, will there be some maximum payout if it's for someone who's a high earner? And just briefly, in the proposed legislation, again, we will let all of you know if you still get our client alerts and all our HR updates, you're always free to delete them, but I think a lot of you enjoy getting them. You're going to see that the current bill proposes a cap of $1,000 per week. So as Alex said, it's going to be 66% of wage replacement, but a maximum of $1,000 per week for that limited period of time. And again, we will see what the final law says, but it's happening. It is bipartisan. And at the next webinar that we do, there's a good chance that we will have paid family leave on a federal level in our country and on a much broader level than what we saw on the FFCRA. Alex, topic number 4, okay? I don't know what else to call it. I know at Chili's, they have the quesadilla explosion salad. We call this the ADA explosion. I don't know what else to call it. There is an ADA, American with Disability lawsuit explosion right now going on in our country. I don't know how else to say it. I don't care what state you're in. These lawsuits have been coming at a fast and furious rate that I have never seen in almost 28 years of doing these kind of cases. And briefly, Alex, prior to COVID, prior to March of last year, I think it was last January in 2020, you and I spoke to a bunch of HR professionals, and I remember, I think it was in New York, and someone asked us, what do we predict is the next big wave of lawsuits? This is pre-COVID, okay, pre-COVID. And we talked about these ADA lawsuits are coming at this incredible rate, and the single reason is mental health. The United States, by every statistic, is suffering through a major mental health crisis in terms of its citizens. When you look at statistics for depression, for anxiety, for bipolar, for just all types of mental health related issues, many of which also result in prescription drug dependency and everything else, what we've seen with the ADA is actually very interesting. When it first became law, when George H.W. Bush, the first George Bush, signed it in 1990, the focus was on, I remember the signing ceremony. How old were you then? I don't even know, but
I don't want to tell you.
I don't tell me, but I was in law school, and at the signing ceremony for the ADA, President Bush was surrounded by fellow World War II veterans, the greatest generation who served with him in World War II. You saw wheelchairs and walkers, and you saw these folks who basically were getting a well-deserved thank you from the government. And we were saying to them, we appreciate your service to the country, and now we're going to help you with your injuries and ramps and sidewalk improvement and elevator improvement to make your lives easier. But the focus was more physical, even though the law did contemplate mental and mental health issues. But since then, we now get more mental health ADA cases than we do any others. And all of you in the HR world need to do exactly as Alex said minutes ago about this interactive process, that when someone comes to you with what they used to call the invisible disability, they look healthy, they look fine, but they tell you they feel sad, they feel depressed, they need some time off, they don't know what's wrong with them. A lot of these issues obviously exacerbated by COVID and remote work for up to 12 months already. You need to take those complaints as seriously as you do one with a physical disability. There is no difference under the law. And I'll leave you with this, Alex, and then you can take this over on this point. You need to show your work. I said that to someone yesterday, and they were laughing like they were speaking to their child in 3rd grade mathematics, when the teacher says, well, Johnny, you got the answer right, but you didn't show your work. It's the same thing with the ADA. You need to take notes. You need to send them an email. You need to show that you asked the employee, what can we do for you? What sort of reasonable accommodation would you like? Then they'll send you their reasonable accommodation proposal. Then you and HR have to look at it, evaluate it, investigate it. Maybe you can accommodate them. Maybe you can't because it's an undue hardship. Maybe you can meet in the middle. But even if the result is that you can no longer accommodate that person, and even if the result is you may have to terminate that person, show your work, build the file, speak with your attorney, and make sure, just like with mandatory vaccines, Alex, it's the same exact point. Make sure that you have a record, that you tried to accommodate the best you could, and either you did it or you didn't, but you made the effort. And Alex, we have had very good results in many lawsuits, getting them dismissed under the ADA because the judge was satisfied that even though the accommodation couldn't be met 100%, the employer tried their best. Thoughts on that?
So from a legal perspective, Peter, I know you and I have had long debates about whether using the phrase quote unquote mental health was enough to trigger any obligations for the employer to engage in the interactive process. And what I could say to that for everybody here on this webinar is let Peter and I have that debate. What you should do, just from a best practices perspective, is still engage in that interactive process. Don't get tripped up by investigating whether or not the veracity of that mental health suggestion or assertion or allegation. We'll deal with that on the back end. Okay. What you should do as employers, and in order to protect yourself, and in order to what Peter called building the file, just engage in your interactive process. You can very well conclude that there's nothing else for you to do. There's no way to alleviate whatever quote unquote mental health issues the employee is dealing with. But again, let us deal on the legal side with what mental health does and what it means in defending a claim for ADA discrimination. Okay, just continue engaging in the interactive process, continue building the file, continue doing what you need to do so that you can show a court. You can show that you've done everything in your power and you've exhausted all avenues and you did more than you were required to do by considering, for example, a workload reduction, by considering, for example, a change in role, transferring position. Many a times those are not going to be feasible. And maybe those are the only things that could reduce the asserted mental health issues. If that's the case, then at least you've done your job. You've done what you're supposed to do under the interactive process. Just don't get tripped up with trying to challenge the veracity of the mental health allegation or the issue.
And that's a great point. And just to wrap up this section or this topic, leaving mental health for one moment, I just got a great question. And the question is, under the ADA, where do we fall in terms of the COVID long haulers? That is a great question because we've had 3 calls on that in the past 2 weeks. And this is the issue. As we all know, people get COVID, then they come back to work. Some of you require a negative test, some of you don't, but you wait the allotted number of days. They're no longer infectious, they come back to work. What about the employee who had COVID 6 months ago? But he or she, they don't feel right. They don't feel the same. They are what we call long haulers. Some call it chronic COVID. CDC now calls it long COVID. And you guys are going to see more and more of these cases where someone technically is COVID negative, but they're long haulers, which means they're still suffering from some sort of brain fog, sense of smell issues, respiratory difficulties, incredible fatigue. Each of those conditions, forget that the FFCRA is gone. Those are ADA protected conditions. Anyone who is a COVID long hauler has ADA protection. And they also, in the next 2 months, we expect an announcement from the Social Security Administration that they may very well be eligible for Social Security Disability Insurance, SSDI, long-term disability. So again, be prepared for the mental health issues, which are coming at an incredibly fast rate. Continue to offer EAPs, employee assistance programs, which are getting more requests now than I've seen ever. Continue to interact with your employees, take every request seriously, and show your work. Very, very important on that point.
And
next issue.
Peter, one more thing before we go. We got another interesting question. I'll do this one quickly. The question is, if you transfer a position or reduce the workload of an employee as an accommodation, can it be seen as punishing the employee, or in other words, retaliating against the employee? And the answer, and Peter, I don't know if you want to jump in, but the answer is no, you do it correctly. And what I mean is, if you do it correctly, just don't decrease the wages. is if there's no harm to the pocket of the employee, it's going to be harder for them to say that that they're retaliating against. So don't decrease the wages, don't decrease benefits, don't challenge seniority benefits or anything like that. Basically, everything stays the status quo except job duties. That's it, or maybe job title.
And I just got another question, and again, I know we have to be off in about 10 minutes, so I'll go quick on this one, but this is a fantastic question. Question is, have we seen what we expected in terms of the number of COVID lawsuits, not the ABA COVID lawsuits, but lawsuits where the employee says or the customer says, I got sick at work. I got sick from your employee. And the answer is thankfully no. This whole avalanche of lawsuits that everyone had predicted, there was talk about Congress instituting a liability shield so employees could not sue their employers for getting sick. So employees could not abuse the workers' comp system for getting sick. So customers could not sue a store or a retailer because they got sick. There was these dire predictions. And I love to give some good news once in a while. The good news, Alex, as we talk about regularly, those lawsuits came so infrequently. And the reason is the best lawyers out there made a determination, the ones who like to file lawsuits, that they had trouble proving causation. The thing with COVID, and we have some doctors who are on, and I hope I'm saying this properly to all the doctors listening today, but it's very hard to show the way the virus is exactly how you got it. Did you really get it from your manager at work? Or did you get it from your neighbor who came over last night? Or you get it from your child at breakfast and maybe your child got it at school? Causation is very difficult to prove. Thus, the COVID lawsuits in terms of getting sick have really not materialized at the numbers predicted. So that's some very good news. All right, topic 5, I gotta move quickly. 1099 misclassification, guys. This is huge, okay? I mentioned this in December. If you work with Alex, if you work with me, if you work with any employment lawyers, hopefully you've been warned about this. There are too many of you and too many companies who have individual workers and you've classified them as a 1099 contractor when we all know darn well they are really, truly W-2 employees. Please, let me give you one homework assignment, and it's more urgent now than ever because of Biden's appointments at the Department of Labor that we're going to talk about in a minute. Please, please, please make a list on your own time, off the clock, not with us, of every 1099 contractor you have in your business. And whether it's your lawyer or your accountant or yourself, make sure someone tells you that each of those folks is a legitimately classified 1099 worker. Because I'm getting a little tired of companies, clients getting sued on this issue, getting audited by DOL on this issue. And the client will say, but Peter, they signed a 1099 agreement. But Peter, it was their idea. They wanted to be a 1099. Or this one, hey, Peter, we pay them corp to corp. I don't pay them directly. I pay them through their company. So all of a sudden, like magic, that makes them a 1099. Not true, not true, and not true. I'm not going to bore everyone with the details other than to say this. There was the case last week from the Supreme Court of Great Britain. And you're saying, why is he quoting a Supreme Court case from Great Britain? The reason is Uber lost a huge case in Great Britain last week that is going to have repercussions in the United States. And the decision basically was that Uber drivers, kind of like Lyft or DoorDash or Grubhub and all the others, that these drivers, at least in the gig economy context, must be classified as employees. Putting aside California, which is a separate issue right now, I don't want to turn to that. But the point of the decision in England was, and the two words are, that the court determines that these employees are in a position of subordination and dependency in relation to the company. Subordination and dependency. So if you guys have 1099s, but they have schedules and they work for you every day, and they have an exclusive relationship with you, and they wear the company uniform, and they get the employee handbook, and they get disciplined, and they get reprimanded, and they are in positions of subordination and dependency. The new administration in Washington, the new Department of Labor, the new IRS are going to come after you at some point, because this new administration has been very vocal about their dedication to the issue of misclassification. If you've already done this, ignore everything I've said, but please, on your own time, do a self-audit. Make sure your folks who are 1099s are real 1099s and not pretend 1099s. Alex, wrap up that issue and we'll move on.
Just quickly, when President Biden was inaugurated, there was an executive order that put basically on hold the Trump administration's proposed rule on independent contractors. That rule focused on control. What President Biden will inevitably look forward to putting into law will be a rule that pretty much mirrors the much tougher California rule on independent contractors. That's what's known as the ABC test. So without getting into that nitty-gritty, we can do that at a later time. Employers need to be prepared to be subject to much tougher restrictions on independent contractors, because it's coming.
And speaking of it's coming, and this is a perfect segue to our sixth and final topic in about 2 minutes. And we knew this was going to happen, but now we have names to give you. And you can Google these names and read about them. But if you work in HR, you need to know who the new leaders are on the issues that we're talking about, okay? The next Secretary of Labor, who's going to run Department of Labor, is Marty Walsh. He's the mayor of Boston. He's going to be approved by a majority of the Senate in the next few weeks. And Secretary Walsh is going to be very, very pro-employee. He has spent much of his career talking about issues such as misclassification, such as gender equality, such as LGBT rights in the workplace, such as mandatory mask wearing in the workplace, such as basically any issue that you deal with. Unionization is a big issue for soon-to-be Secretary Walsh, meaning the rights to bargain, the rights to organize. And what you're going to see under the new Department of Labor are more audits, a bigger budget, and more investigators whose job it will be to go around the country and ensure that there is more compliance with Department of Labor rules than ever before. The last name I'll leave you with, the United States Equal Employment Opportunity Commission. The new chairperson is going to be Charlotte Burrows. Ms. Burrows has a very good reputation. She's a very strong advocate for employee rights. And for any of you who have or have had EEOC investigations, they're going to become a little different over the next few years. You're going to notice that the investigators are going to be in contact with you more frequently. Alex and I have noticed that of our pending EEOC cases, even since January 20th with the new administration, the investigators are calling more. One of them told me that she's very happy because they know their budget is going to be increased, they have more help, and that they really are going to spend more and more time ensuring that laws which prohibit discrimination based upon race, religion, national origin, gender, age, disability, pregnancy, all of these laws, the government is going to spend more time and more effort on enforcement, and all of you need to know about this. And Alex, in conclusion, I think it's kind of how we concluded back in December when we spoke to everybody. Everyone needs to get their house in order. Do not wait. What we're talking about today is a fraction of the cost of litigation, and it is all very predictable. HR folks always tell me that they hate the unpredictable. Well, guess what? Unlike COVID, unlike what happened over the past year, which no one saw coming to that extent, every issue we spoke about today is predictable. The issues are here. You can fix them preemptively, and you can ensure that you are another employer, another organization who sees a dramatic diminution in lawsuits and not an increase. Alex, want to wrap it up?
Guys, be proactive, not reactive. Those are the words that everyone should be living by in this webinar. That is all, Peter.
Perfect. Thank you, Alex. Thank all of you for being here. If you're still interested, we'll do another one of these in a couple months, and we will continue to keep you posted. Thank you and enjoy the rest of your day.